Testing. Judge Mike 7. Testing. Judge microphone 6. Judge Mike 5. Judge Mike 5. Okay. Judge Mike 4. Judge Mike 3. Judge microphone 2. And Judge microphone 1. Lavalier, yep, Lavalier 1. Testing, testing. That's a little way. And Lavalier number 2. Okay.
Good afternoon. You can be seated. The matter before the court is BCD 25-296, John Veneziano versus Bernard Saulnier et al. I see counsel are present. I'm assuming ready to proceed. We are being streamed both by audio and by video on the web. If, before we begin the argument, I would ask counsel to please identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
If it may please the court, Jeffrey Bennett. I represent defendants, Mr. Saulnier.
Good afternoon, Your Honor. Kyle Noonan here on behalf of the plaintiff and appellee, John Veneziano.
Thank you. And Attorney Bennett, if you're ready to proceed, we'd be happy to hear your argument this afternoon.
I am. Thank you, Your Honor. If it may please the court, we're here on a special motion to dismiss, an appeal from a denial of a special motion to dismiss. Under Maine's Uniform Public Expression Protection Act, a party may file a special motion to dismiss if two elements are met. First, the complaint, in whole or in part, is based on protected or defined speech. And second, if the cause of action otherwise would be subject to dismissal on a Rule 12b6 motion to dismiss. Absent protected or defined speech, a party can still file a motion to dismiss. It just doesn't take priority on the court's docket, and a party does not have a right of interlocutory appeal if the motion to dismiss is denied. That's it. Other than that, that's all the Uniform Public Expression Protection Act provides for. It's a marked difference from the anti-SLAPP statute that actually eliminated certain causes of action. This statute doesn't eliminate any causes of action. The complaint in this case is based on defined speech. Statements made to a court. Count 3 of the complaint, if you read it in its entirety, every single paragraph asserts that my client misrepresented facts in his sworn testimony in the court proceeding. Every paragraph. So to say that this case is not based in whole or in part on defined speech, a statement made to a court, is wrong. I don't think it can be credibly argued that each count of the complaint is not based, at least in part, on my client's testimony. That being said, the real issue before the court is whether or not the complaint states causes of action for each count. Count 1 of the complaint is for transfers under the Uniform Fraudulent Transfer Act. The Uniform Fraudulent Transfer Act requires pleading with specificity. The first asset allegedly transferred fraudulently is it's a theory that my client has provided work in exchange for gifts being made to other family members in order to prevent the plaintiff from recovering on a judgment. There's theory there. It's alleged based upon hypotheses, but there's no specificity.
Counsel, can I go back to the green light is on, to whether the cause of action is based on the speech? There's a request, obviously, for damages and to avoid transfers, et cetera. In this case, is Mr. Veneziano claiming in any way that he was damaged by what was said in the testimony, or is he claiming that his damages arose as a result of what he did Do you see the difference?
I do see
mean,
the
he's not actually claiming that he was damaged by what he said and that that's what he's seeking damages for. Isn't he actually seeking damages for what was done, i.e. improvident, correctly or wrong, I mean, rightly or wrongly, but by the improvident transfers, et cetera?
He's claiming both. In count 3 of the complaint, he's exclusively claiming that there was a fraudulent misrepresentation made based solely and exclusively on the in-court testimony. So for purposes of count 3, fraudulent misrepresentation, it's entirely 100%, and it's only 6 paragraphs. It's entirely 100% based on the in-court testimony, and the concluding paragraph says, Mr. Veneziano has suffered harm and economic damage as a result. As a result of what? The in-court testimony. That's the entirety of count 3, fraudulent misrepresentation.
But he's alleging that he was damaged by the things that occurred that perhaps at the disclosure hearing were not represented, but it's the things that occurred that he's claiming he's damaged now, not by the fact that somebody walked into a disclosure hearing and said blah, 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 which turned out to be incorrect.
He's alleging both, Your Honor, respectfully, and I'll give one example that makes it very clear and simple. Mr. Saulnier does not earn $350,000 annually, but he believes he could earn $350,000 annually if he was fully and gainfully employed as a real estate developer. He testified to that in the disclosure proceeding, and that is asserted as a basis for the complaint. That testimony is asserted.
So does this new, I'm going to call it the new Anti-SLAPP Act because I have trouble dredging up the new name on short notice. Use an acronym. It's intended to discourage, to head off frivolous lawsuits where people are really just exercising their First Amendment rights. In this case, your client was subpoenaed to come down and give comments under oath, and now it's claimed that they're untrue or incorrect. But I just want to ask you, as you know, there are 3 elements that are folded into the analysis here, and I'll just ask you to address all 3 of them and take part of this from the appellee's brief. They say, first, Mr. Saulnier's disclosure proceeding is not a matter of public concern. Second, claims against him are not based on a disclosure hearing. I guess we've talked about that a little bit already. And finally, Mr. Saulnier's disclosure hearing is not otherwise privileged. So is the disclosure hearing a matter of public concern that he's speaking out on?
Well, all court testimony is, all court cases are. The United States Supreme Court has said so. I cite that in our brief. The in-court testimony is sworn and it's public. It's announced publicly. This is a public proceeding that we're in.
But is it a matter of public concern? Are you saying everything that happens in court, even now, is a matter of public concern?
Of course. Oh, it is. These are public courts. This is part of our constitutional bedrock, that the courts are open to public, that the media may participate, that the public may attend. And courts are stare decisis in this country.
That's a wide net you're throwing there. So someone comes to small claims court and says, my neighbor stole my dog, that's a matter of public interest or public concern?
Absolutely, because the decision, firstly,
Is that rooted on the fact that constitutionally court proceedings, with some exceptions obviously, are public proceedings and the public forum, and so that regardless of what the topical matter is, it should be considered an issue of public concern, at least for
of
that
public
context.
concern, and the United States Supreme Court has said, and Craig v. Harney, a trial is a public event. What transpires in a courtroom is public property.
But does it give rise to a cause of action? That's a hypothetical case, not this one. Mr. Jones goes to court and lies. Is that, and someone sues him for whatever he said there, and that is subject to an anti-SLAPP motion? You can throw that out of court just because they've misrepresented something?
In Maine, if Mr. Jones went to court and lied and was sued for his lie under oath in a court, he can't be sued, because in Maine, you can't be sued for your in-court testimony for any reason whatsoever. You can be charged, under the perjury statute. That's the sole exception in Maine.
That's another argument. I mean, you're suggesting that anytime somebody testifies in court, that it's immune, it's privileged.
Correct, and there's a long line of cases that date back 100 years.
There's a line of cases saying that you can't be held liable necessarily on account of the statements that were made, but that if the testimony about something you did, you could still be held liable for what you did.
You can be held liable for what you did, but you can't be held liable in a court for what you say. And here, if a cause of action is based on something you said in court, regardless of something you may have done outside of court, if it's based in whole or in part, all that does is it triggers your right to pursue a special motion to dismiss as opposed to a traditional motion to dismiss, which simply means that the motion will take priority on a court's docket, and if the motion fails, a right of interlocutory appeal. But you still have to prosecute successfully the motion to dismiss.
If Mr. Veneziano brought the action and nothing in the complaint said anything about the disclosure hearing, could that conceivably be subject to anti-SLAPP? I would think not, because there's no statement.
If the action's not based on in-court testimony or defined speech under the statute, then the answer to that question would be no. It would only be subject to a traditional motion to dismiss.
Right.
But here, over 29 paragraphs, 30 paragraphs in the complaint cite to the testimony. The complaint cites to and incorporates in the deposition testimony of both Mr. and Mrs. Saulnier and the in-court testimony transcript of the parties. And so the testimony itself is part of the complaint, an integral, inseparable part of the complaint. And so to suggest or say or argue that this civil action is not based, at least in part, on defined speech under the statute, which simply gives the right to prosecute a special motion to dismiss.
I'm going to anticipate that what we're going to hear in just about 1 minute is that, no, our claim is based upon the fact that fraud occurred, and we learned about it during the disclosure hearing. Your response with 50 seconds left?
If they could not otherwise bring the cause of action absent the testimony, then by definition, that civil action is based in part on the defined speech that gives rise under the statute to merely pursuing a special motion to dismiss as opposed to a traditional motion to dismiss.
But Mr. Bennett, the complaint seems clearly based upon what Mr. Veneziano is saying Mr. Saulnier did, and he's quoting the testimony as evidence of what Mr. Saulnier has acknowledged doing.
Not in count 3, and not in each and every count. In part, yes, for certain counts. In count 3, it's entirely based upon what was said from the stand. And in each and every count, in part, it was based on what was said from the stand and based in part on conduct that occurred. Regardless, it simply opens the door to a special motion to dismiss, and for the reasons argued in the brief, each count fails on its merits because elements are missing for these types of actions.
Thank you, counsel. Attorney Noonan, we're happy to hear your argument.
Thank you, Your Honor. Kyle Noonan here on behalf of the appellee, John Veneziano, who's here with us with his wife, Debbie, today. May it please the court, you've heard no argument today that this lawsuit is a retaliatory effort to chill Mr. Saulnier's speech or other constitutional rights. Mr. Veneziano obtained a $3.5 million judgment against Mr. Saulnier in 2021. Exactly $50,000 have been paid. Mr. Veneziano filed suit because he is the victim of a coordinated fraudulent effort by Mr. Saulnier, by his wife, by his kids, and by his employer and business partner, Mr. Moore, to keep income and assets out of Mr. Saulnier's hands, but still make them available to him through his family members. That's all designed to avoid the judgment. This is not what the anti-SLAPP statute protects. The anti-SLAPP statute, both the old version and the new version, They target plaintiffs who file suit not primarily intending to win, but to delay and to distract and to impose costs on activists and others who speak out. The prototypical example, of course, is a developer who files garden variety tort claims, such as defamation, against neighbors who oppose a development project. That's just not what we have here. Mr. Veneziano very much filed this lawsuit to win it and to collect the money that he's owed. Even if the court finds that the anti-SLAPP statute applies here, the statute only operates to dismiss meritless claims. Each of the claims asserted against Mr. Saulnier withstand 12b6 and 9b scrutiny easily. This is an unusually detailed complaint. It is supported by hundreds of pages of exhibits. And at the end of the day, Mr. Saulnier is asking this court to effectively immunize him from liability for fraud because he testified about that fraud and furthered that fraudulent scheme through testimony in a disclosure proceeding. The trial court's denial of the special motion to dismiss should be affirmed. Let me just talk a little bit about the anti-SLAPP statute. Again, there's no argument here, you didn't hear it today, it's not in the papers, that the lawsuit is a retaliatory effort to chill Mr. Saulnier's speech or his constitutional rights. That's the purpose of the anti-SLAPP statute, and it's actually memorialized in Section 741 of the new statute. Next, testimony at a disclosure proceeding by a judgment debtor about his income and his assets, it's not a matter of public concern. I've done a couple of these over the years. You ask the judgment debtor, do you have a snowmobile? Do you have a boat?
Well, I see that the green light is on. I think, while one could certainly agree that most people may not care whether the debtor has a snowmobile or a boat, I think Mr. Bennett's argument is that simply by virtue of being statements made in a public forum, which is, that makes it a matter of public concern. For the same reasons that other courts have said that, in other words, that open courts are central to our constitutional system of government.
If you look at the cases that this court decided applying the old version of the anti-SLAPP statute, Section 556, and I think that that case law is by and large good law for a number of reasons. The statute is different. We now have the uniform.
We understand that a lot of it is still probably worthy precedent, but didn't we also say, haven't we, I guess I'll go to your statements about that, this isn't a lawsuit, there's no evidence, no testimony, this is a lawsuit that's retaliatory effort to chill the exercise of someone's rights. Whether or not that is true, I think we've actually sort of commented in the past under the anti-SLAPP statute that essentially it was far more broad, even though that may have been the intent. It's written very broadly, and that's always, this court has struggled with a lot of these cases because it does, on its language, bar far more things. It may appear to bar what might otherwise be, a good tort claim, shall we say. So can we put that one aside? We have to deal with the language of the statute here.
So my position would be that the constitutional issues presented by a very broad reading of this statute are the same constitutional issues that were raised by a very broad reading of the old statute. The old statute's used based on to link the protected conduct and the claims. The new statute does the exact same thing. It uses based on. But this court has held in the past that based on language means based solely on.
I understand. Can I direct you to count 3 that Mr. Bennett has raised? And if you look at count 3, as opposed to the fraudulent transfers that occurred outside of the courtroom that most of the claims are based on, count 3 does appear to state a claim based on his testimony.
And his testimony was in furtherance of a larger fraudulent scheme to prevent Mr. Veneziano from collecting on the judgment.
I understand that that's the broad picture of the testimony, but count 3, when you look at it, does specifically say that, he made material made fraudulent representations of material fact during his testimony, that he knew the testimony was false, made representations with reckless disregard, and for the purpose of preventing him from enforcing the judgment. And as a result, he's been unable to enforce the judgment and has suffered harm. How is that count, putting aside the other ones? Now, I understand that's not the end of the story anyway, but how is that count not based on his testimony?
So if you look at Hearts with Haiti, what the court did there is it looked at the overall complaint, it looked at the allegations, and it said, this is just not the kind of case where the anti-SLAPP statute applies.
So are you suggesting then that even if count 3 would otherwise shift the burden? I mean, it's not the end of the discussion in any event. Essentially, the burden would shift to you to make sure that they're established a prima facie case as to each element in any event. But putting that piece aside, are you saying that if one count out of a multi-count complaint might have been based on the in-court testimony, but the overall gravamen, if you will, and the other counts are all based on the conduct that was discussed in that testimony as opposed to the testimony, then none of the counts ought to be dismissed?
That is what I'm saying, Your Honor, and that's consistent with the court's approach in Hearts with Haiti. There are also, to hold that the testimony in a disclosure hearing is protected by the anti-SLAPP statute is inconsistent with the purpose of the anti-SLAPP statute. That's to protect against meritless retaliatory lawsuits brought to
Can I just
children.
ask you, following up on that point, obviously, as you know, in a cause of action for fraud, we require specificity in the complaint. You need to lay out exactly what it is that constitutes the fraud. And the disclosure testimony looms large in count 3. If you were to excise any reference to the disclosure testimony, would there still be enough left in count 3 for it to fly as a fraud action?
I think so, because there's an overall fraudulent course of conduct that's occurring here. If you look at the exhibits to the complaint, cut out the disclosure hearing testimony, there's still a large number of exhibits that were obtained.
So if that wasn't included in your complaint, I think we heard we wouldn't be here on this. We'd be here on a generic motion to dismiss, not an anti-SLAPP motion to dismiss.
I think you would still be here.
Sooner or later, for one reason or another, but
I think you might
perhaps
still be
not
here.
on anti-SLAPP.
I think you might still be here on an anti-SLAPP statute, because to be sure, the disclosure hearing testimony is a key part of the evidence supporting the allegations.
Can I ask you just generically and hypothetically, in a generic disclosure hearing, the debtor is brought in under subpoena and asked questions under oath. Is there any I'm asking you to play devil's advocate here. Is there any circumstance where, under that scenario, where that could create a cause of action in fraud if the person is being untruthful in their answers?
Well, I certainly hope so. It would certainly be bizarre if you can commit fraud outside the courtroom, but then when you testify under oath, that is somehow immune from fraud. We have a whole string cite on page 24 of our brief that lays out cases that hold that you can be liable for fraud even when you're testifying under oath. That's certainly, for other claims like defamation, there may well be immunity. Not the case for fraud, and that's the black law position. It would also really be quite a slap in the face to judgment creditors if a judgment debtor could lie under oath in a disclosure hearing with impunity. That would, I think, not be consistent with the Money Judgments Act, which authorizes the disclosure proceedings. And it would certainly, I think, it would be inconsistent with the legislative intent of UPEPA. I don't think anyone in the legislature imagined that when they passed UPEPA, when they enacted it here in Maine, that they were weighing in on a creditor's rights issue here in Maine.
I think you heard Mr. Bennett say that any testimony given in any courtroom is a matter of public interest, public concern. I think he said something to that effect. Your response?
So if you look at maybe the Eckroat, which was a decision in federal court by Judge Levy, he parsed whether a party endorsing a letter which then a counterparty sent to a state agency. And I think reading between the lines, the party that endorsed the letter knew that the endorsement would end up before the state agency, whether that was petitioning activity under the old version of the anti-SLAPP statute. Of course, the old version protected petitioning activity or right of petition.
But that's not testimony in a courtroom.
That's right. That's right.
And isn't that a different animal than other kinds of things?
Well, yes, but the point I'm trying to make is you can really use the old case law if you just replace the protected conduct with right of petition. Take right of petition and replace it with matter of public concern. That's the point that I'm trying to make with that tangent. But in maybe the Eckroat, the court said this is just not within the ambit of the anti-SLAPP statute, because this private letter sent between private parties is just not. There's no constitutional rights implicated. There's no right of petition implicated by that decision.
So even if the testimony or if the complaint is based upon the actual content of the testimony as opposed to separate conduct, your position is that none of the complaint could be dismissed on that basis to the extent that the court found that the complaint had been generated by the testimony?
Well, I think if the testimony is merely a part of a larger overall fraudulent scheme, the court shouldn't dismiss that count or those counts, because that's the approach that the court took in Hearts with Haiti. It basically looked at the overall allegations in the complaint and said, this is just not, the overall allegations are just not the kind of thing that is protected by.
Well, isn't that sort of also another way of saying that essentially, even if count 3 were based on what he said and it's a matter of public concern, because all court testimony is a matter of public concern, nonetheless, it doesn't get dismissed because the complaint as a whole, which is a verified complaint, establishes essentially a prima facie case as to each element on each count.
That is a much better articulation of what I'm trying to say.
Okay.
Yes, Your Honor. Let me just briefly, while we're talking about this, I'd like to. We haven't discussed at all Madawaska v. Kayer. In that case, the court held that the claims are based on the protected activity only if they are based on the protected activity alone and have no substantial basis other than the constitutionally protected activity. Now, in Kayer, which was decided under the old statute, the question was, does this implicate the right of petition? Now the statute obviously still applies to that, but it adds this element of matters of public concern. And what the court is saying there, and in Kayer, this court observed that to read based on more broadly would so severely damage a plaintiff's right of access to the courts as to raise serious constitutional issues, which this court explored in Nader 1 and another case which is escaping me. But if this court takes the appellant's position, it's basically saying that a judgment debtor is thrown out of court just because a judgment creditor is thrown out of court just because a judgment debtor lied under oath in a disclosure proceeding. That can't be right. That's certainly not what I think the legislature intended to do with UPEPA. And it wouldn't make sense. It would trample upon the rights of judgment creditors. Let me just say briefly, there's an empty chair here. Shannon Linehan, my co-counsel, is not here today. She actually had a baby a week ago. So I wish that she had been here to do this argument. But thank you.
Well, Shannon was recently a clerk in this court, so send our congratulations to her.
If I may, thank you. With all due respect to counsel, counsel either misunderstands the appellant's argument or is rewriting the appellant's argument. And the anti-SLAPP statute has absolutely no relationship to the current uniform public public
So we can't
expression
tap into our
protection act.
prior jurisprudence to interpret this?
I would suggest not, and I'll explain briefly why. The SLAPP statute actually protected and immunized speech. You could have a valid cause of action for defamation or a valid cause of action for wrongful civil proceedings, but if it was based on the protected speech or conduct under the anti-SLAPP statute, you could not bring those claims. Here, under this statute, no claims are immunized. Fraud is not immunized. Defamation's not immunized. Nothing's immunized. All this statute says is that if a complaint fails to state each element of a claim so that it's meritless, and in addition, it's based upon defined or protected speech, then you can bring a special motion to dismiss, but you still have to prove each of the counts are meritless. So if this action were based on speech, or protected or defined speech, which it is under the statute, it's now the burden still exists to demonstrate that each count is meritless. You didn't have that under the former statute. Hearts of Haiti, that analysis doesn't apply. Nader doesn't apply. Those cases no longer apply because all causes of action that are valid proceed, regardless if they're based on in court or other defined speech. And all causes of action that lack an element and are meritless fail, and you just get an early expedited review. Your case simply takes, your motion takes priority on the court's docket. This statute does no more than that. So if we revisit the statute, everything we just heard from counsel is irrelevant to the pending motion that was filed in this case and this appeal. If there no testimony in court immunizes a party from fraudulent conduct. That's not what this case is about. That's not the argument on appeal. The argument on appeal simply is because the complaint, at least in part, which has been now admitted, is based at least in part on statements made in a judicial proceeding, which doesn't require public it doesn't require a public concern. Only petitioning activity under the current statute requires public concern. Under the statute, any statement made to a court opens the door to a special motion to dismiss. Now the sole issue remaining is, do the counts have merit? And the counts here are meritless, markedly meritless. This is an overreach of a civil action. We do have a judgment creditor who is owed a lot of money. We're not disputing that. The problem is they're being creative, trying to create from law causes of action that don't apply. Thank you, Your Honor.
Thank you, counsel. Thank you for your argument in this matter. Mr. Bennett, we'll see you again in a few minutes. But for this matter, we will be taking it under advisement and issuing a written decision in due course. Thank you.
All rise.
be seated. The matter now before the court is BCD 25-193, John Veneziano versus Bernard Saulnier. And I see counsel are present. I'm assuming you're ready to proceed. And again, we are being streamed live on the web, both by audio and by video. And if counsel who are arguing would identify themselves by saying your names for the record together with the party you represent, starting with appellant.
Jeffrey Bennett, I represent Mr. Saulnier.
Good afternoon, Your Honors. Jana Kenny and William Galito here on behalf of appellee John Veneziano.
Thank you. And Mr. Bennett, we're happy to hear your argument.
Thank you. If it may please the court. We are here because the disclosure court erred when it issued its order directing my client to make installment payments based upon phantom income. Nothing in the Enforcement of Money Judgments Act authorizes a disclosure court to impute income. Imputing income is only authorized by the legislature under Maine law in one circumstance, and that is for the payment of child support. Under the Enforcement of Money Judgments Act, the legislature demonstrated that it acknowledged that one exception in Section 3128-A, titled Order to Seek Employment. The statute reads, if a child support obligor claims an inability to pay in a disclosure proceeding, the court may order the obligor to seek employment in order to make the progress payments. The court, on page 3, concluded, and I'll read, in this case, Mr. Saulnier could and should be earning a minimum of $350,000 per year for his work as a developer. And the court continues, applying the 25% limit to that amount equals $52,500 annually or $1,009 weekly. Under the circumstance of this case, in order to counteract Saulnier's ruse and provide fairness to Veneziano, the court orders Saulnier to make installment payments to Veneziano in an amount of $1,009 per week. And then the court cites, interestingly, Sergeant B. Solomon, which was a proceeding in which a disclosure court lacked the ability to unwind a fraudulent transfer, and that judgment creditor had to bring a separate civil action in an equity court in order to unwind a fraudulent transfer to reach property which had been placed beyond the creditor's reach. And that separate court of equity held that after a judgment creditor exhausts its legal efforts, it may appear in a court of equity and seek equitable relief to unwind a fraudulent transfer. The decision, the reference by no means supports what the disclosure court did in this case. The legislature has not permitted anywhere within the statutory scheme imputation of income, but yet on its face, that's exactly what this installment order is. It's an installment order based upon assumed income, which is, it doesn't exist. If the court has questions, I'm happy to answer questions.
I'm just going to ask you, would you agree that there's a distinction between imputed income and inferred income? And let me just elaborate on that for a second.
There is.
Imputed income means no money actually came in. I'm going to impute that, you would have had this. Whereas indirect income that would be inferred by other sources would refer to income that actually is coming in. Is that a fair distinction?
Yeah, I think there's a distinction between inferred and imputed. I think a court first would infer income and then impute it to the judgment debtor. That's what happens in family court.
Yeah, I'm not sure, but I think you say the court can't infer here because there's no statutory basis for it.
Or impute. It can't do either.
I'm sorry. Can't impute. Let's start with that one. Okay? Now let's go to infer. If the judgment creditor has income And earnings, as we know, is defined by statute, but has sources of income from other places that is not coming directly to him, but benefiting him. Cannot the court infer, not impute, but infer that that is, in fact, disposable income coming into that person?
Under the Enforcement of Money Judgments Act, a court can only do what the legislature has authorized. And what the legislature authorized is that the court can take into consideration any factor. So if the court wants to take into consideration what Your Honor, Justice Meade just alluded to, a court can take that into consideration. But the statute does not then proceed and then provide the court unbridled discretion in fashioning a remedy.
But earnings is very broadly defined. I mean, under 3121 subsection 1, earnings means compensation paid or payable for personal services, whether denominated as wages, salary, commissions, bonus, or otherwise. And certainly if, for example, the provision of unusually large benefits, for example, let's assume we didn't have the issue of spouse versus the self or something like that. But isn't earnings, wouldn't that include if somebody's given, say, a free house and they're given all their meals and a personal chef and a car and everything else? I mean, doesn't that come in as compensation? I know that's not exactly what happened here, so don't start telling me that that's not. I know it's not. But if that were the case, let's say you had an individual who is earning a nominal amount, a minimum wage, right, in terms of their wages, but they're also being given a free house, a personal chef, a driver and car and everything else. I mean, cannot the disclosure court consider that as earnings? It's compensation, isn't it? You'd certainly have to pay taxes on it if you were being honest.
I'm going to take that in reverse, so I answer your question first and then take us back to the definition of earnings. So if those benefits were coming from the employer to the employee, then I would suggest that the court might be in a position to say that's income, that's earned income. So for instance,
it's earnings. So the statute doesn't use the word income.
So in certain industries, such as some restaurant industries, migrant workers will be given housing in addition to some amount of wage. And I think a court might say that the free housing supplements the earned income, and a court might take that into consideration. Here, the benefits that are alleged to have been provided to my client are alleged to have come from his wife and from his son, not from the alleged employer, in this case, which is a gentleman named Mr. Moore.
So is that really not a question then under these circumstances? I understand that's your view of the evidence, but the evidence may, in fact, is the issue whether the evidence would suggest a contrary finding. In other words, that it really is coming to benefit Mr. Veneziano.
Well,
Mr.
Going back to
Saulnier.
the definition of earnings, earnings is actually a very narrow definition, not a broad one. And it says earnings means compensation either already paid or to be paid or payable for personal services, no matter how denominated, wages, salary, commissions, bonuses, otherwise. But it's earned and paid or to be paid wages to a person. It's a narrow definition.
What does or otherwise mean? Does it mean in addition to those categories?
Otherwise might be what we just discussed, in kind, the housing that a migrant worker may be provided by an employer. But again, that derives from the employer, and it's taxable. Income would ordinarily be taxable.
So if the court were to find that your client's former associate, Mr. Moore, was actually funneling large amounts of money to the family members with the intent that it really be earnings under the definition to your client, can the court make that inference?
The court did not make that inference. The court did not make a finding that there was any such transfer. The court perhaps could have been asked to and may have, but it didn't happen. And so until that happens, I'm not sure how to address it, because I would want to see the analysis in order to then decide whether or not it's a valid or invalid decision under the Enforcement of Money Judgment Act. My position in this case is that the underlying court, on its face, imputed an amount of income, $350,000.
Was there a request for findings?
I was not counsel in that case.
I know, but was there a request that the court explain what it did and make some findings to support its decision?
I am unsure if there was a request at the time for findings. There was no additional.
Let's say it didn't.
There was no additional request.
Let's say it did not. Does that change the way we, as the appellate court, review the record?
In an ordinary appeal, it may. In a situation like this, where it's simply an order for installment payments, I'm not sure that the additional requirement of asking for findings of fact and conclusions of law, if that applies to an order of this type.
Is there a reason why it wouldn't? I mean, Rule 52 applies to any order entered after a non-jury hearing trial.
Let me concede that and say, even if the court should look for anything in the record to support the trial judge's decision, let's assume that, even so, as a matter of law, and this gets back, Justice Mead, to what you were asking in the beginning, there's a distinction between what a court may take into consideration versus the remedies a court has under this statute. Imputing income is a remedy. It's not something that is taken into consideration. So a court could take into consideration a judgment debtor's ability to earn more and then order the highest amount of installment payment.
Can I ask you in the 30 seconds you got left here, I'm going to give you a hypothetical. Professional association, lawyers, doctors, something like that, and one of them leaves the practice officially, but is still doing work. They're still meeting with clients. They're still writing briefs and things like that. And the senior partner says, "This is great that you're giving this to us. So I'm gonna give your wife a free house. I'm gonna give your wife a free car. I'm gonna subsidize their college education." Would the court be out of line by assuming that was actually earnings to the departed attorney?
Under that hypothetical, the court would be out of line. And the reason is that might trigger a tax obligation of income on the part of the wife, depending upon the amount transferred to her. A person's allowed to gift in this country. Gifts are permitted. Judgment debtors are allowed to receive gifts. The issue is, does the gift arise to an amount that it triggers a tax liability? And under the Enforcement of Money Judgment Act, if a debtor is presumed to be earning a certain amount, then the withholdings order or the installment order has to be limited to 25% of actual earnings.
Thank you, counsel. Attorney Kenny.
Your Honors, may it please the Court. In 2021, Bernard Saulnier had a judgment entered against him for $3.5 million. No meaningful progress has been made on that judgment, even though he is working as a successful real estate developer and enjoying a high standard of living. To evade the judgment, appellant has concealed his earnings from judgment creditor Mr. John Veneziano through one or more schemes. After hearing directly from Mr. Saulnier at the disclosure hearing held pursuant to the Enforcement of Money Judgment Act, the trial court determined that until now, Saulnier's subterfuge has been successful. And to counteract his ruse, the trial court ordered weekly payments of $1,009 based on a yearly earnings value of $350,000. Today, appellee requests that this court affirm the trial court's order because it was acted within the confines of the act.
Counsel, I see that the green light is on. I'm going to have to bring you back to a foundational question. This is a judgment that was entered in federal court?
Bankruptcy court, Your Honor.
Was it ever domesticated in the state court? Does the district court have jurisdiction to do a disclosure action in a foreign judgment that has not been domesticated?
Your Honor, I apologize. I do not have the answer to that question. I was only counsel since the disclosure hearing, and I do not have the answer to whether or not it was domesticated.
It's a significant question.
Yes, Your Honor, it is.
Would you like the opportunity to submit some supplemental briefing? And I'll obviously give the same opportunity to Mr. Bennett.
Yes, Your Honor.
Okay. Well, putting that issue aside, go ahead.
Thank you, Your Honor. Mr. Bennett argues that the trial judge imputed income of the value of $350,000 onto Mr. Saulnier. And this is not what happened, at least in the manner that it is used in child support cases. This is not a scenario where a judgment debtor is underemployed or unemployed.
Would you agree that in the disclosure setting here, that there's no authority for the court to impute income?
I would agree in the way that that is used in child support cases, Your Honor. I would ask the court to look to how the IRS defines imputing income for tax purposes. It goes to the conversation you were having with Attorney Bennett, where they put value, monetary value, on non-monetary fringe benefits, things like free use of vehicles or free rent, items like that all...
Let me take you one step further. If in a disclosure hearing, someone's on the stand there, the judgment debtor, and this judgment debtor is a neurological surgeon, but he's working at the local McDonald's just because he doesn't want to pay the amount. Can the judge say, you could be making $500,000 a year, so I'm going to impute that to you. That's what your disposable earnings are, even though they're not there. Is that okay?
No.
Okay.
That is not okay, Your Honor. And I would submit to the court that if Mr. Saulnier chose not to work, then Mr. Veneziano's only recourse is to go to a disclosure hearing every 6 months as allowed by statute. The judge isn't in a position, unless it's a child support scenario, to force someone to work. Mr. Saulnier himself testified that he is working for Mr. Moore. He's also doing some work for his sons. And he self-imposed the value of $350,000.
Where did that come from? I'm having trouble doing the math on that.
The $350,000?
Well, in the testimony or it's testimony, but judge finding. Where is it? I'm not sure. Are you asking where it came from?
Yeah, how did the judge reach that conclusion? That's the amount of disposable.
There are two things. I don't want the court to confuse two lines of questioning that happened at the testimony. There's this one line of questioning where Mr. Saulnier is saying, oh yeah, I had all these job opportunities that they offered me $350,000 plus all these benefits, and I turned them down because I don't want to pay your client. That's not what we're talking about. I'm talking about a line of questioning where the attorney asked, whether Mr. Moore should be paying Mr. Saulnier $350,000 a year. His reply to that was, I'd say yes. So that's where he imposed the value of the work he's performing for Mr. Moore at $350,000.
Okay, but I think I'm worth a heck of a lot more than I get paid. Does that change what would happen if I owed a debt? In other words, I can sit here and say, well, gee, Maine judges are the lowest paid judges in the country, and which we are, by the way, and that, I'm worth at least twice what I get paid. Can you then order something, and by the way, that would be comparable to the Chief Justice of a variety of other states if I got paid substantially more? Because that's what other chiefs are paid.
Not that alone, Your Honor. I think that there needs to be some other support in that testimony in the record. Like in this scenario, the trial judge is a fact finder, right? He was there. He was listening to this testimony. He's able to establish credibility and all those things. Mr. Saulnier testified to all of these other benefits that he's receiving. He also stated at one point that if he's after having already said that he was doing all this work for free, he said, if I'm going to do some work for someone, I need to incentive. I'm not going to do it for free, right? So the judge had before him this testimony that Mr. Saulnier said there's this commercial lease or rental space that he's receiving that he values at $3,000 a month. But he's not paying that because of everything.
But if we go to the record and add all those things up, the $3,000 a month for the commercial space, the truck, et cetera, doesn't seem to add up to $350,000 a year.
Maybe not based on what was in that transcript, Your Honor. I think that raises a great point on whether there needs to be actual findings of fact when there are these earnings that go outside of your traditional wages, right? When we're talking about the value of a free, large truck or...
It would have been easier for us if each of these sources of income had a monetary value and we could add them up on a calculator. But no one made a request for findings here, is that correct?
Yes, that's correct, Your Honor.
Can we just blow past that and say, well, if there's no request for findings, we just assume that as long as the record supports it, then we assume the judge made those necessary findings? Or can we assume that because there's no monetary value in the record?
Your Honor, it's a problem, right? And I think that it would be an appropriate response by this court to remand it asking for more specific findings. But I also think, based on the record, putting the fact finder cap on that the judge was wearing, you can say there was enough evidence in the record based on Mr. Saulnier's own testimony for that judge to make a reasonable inference as to the value of all these non-monetary benefits.
There don't appear to be additional questions.
Your Honors, if there are no additional questions, I will rest on the brief.
Thank you. Attorney Bennett?
Thank you. The disclosure transcript on page 58 is where the citation, that's the citation for where Mr. Saulnier testified to his worth being, in his opinion, $350,000. He also testified on that same page that he had been offered a job that he turned down, an out-of-state opportunity with Consigli Corporation for $350,000 annually. So that's on page 358. The benefits that counsel alluded to are not benefits that Mr. Moore, nothing in the record supports that Mr. Moore provided those benefits to Mr. Saulnier. The record is that Mr. Saulnier worked part-time, 10 hours per week for Mr. Moore, providing consulting, and was compensated $40,000 for that work, and that his sons, independent of him, work with Mr. Moore, and that his wife, who has her own business, independent of him, works with Mr. Moore, and that those individuals received compensation for their work directly from Mr. Moore, and that a son allows Mr. Saulnier to drive his truck, and that's a benefit that counsel from Mr. Veneziano is claiming should be somehow included in an income calculation. Or Mr. Saulnier is sleeping in his wife's home. His wife owns their home, and that's a benefit that Mr. Saulnier should be imputed to and have to base income off of. But nowhere in the record is there that Mr. Moore is providing benefits to my client. Everything in the record is that third parties are providing benefits to their father, their husband. And because of that, the argument that $350,000 or any amount of imputed income. Anything above $40,000 annually should be part of an installment order. It's just not supported by the record below. I'm happy that...
Counsel, would it be imputation or would it be inferring if someone has told you, I just turned down a job for $350,000, and the court then determines, then one would think that one might be able to have earnings of $350,000?
Well, it says income paid or payable, and so if you're going to infer income, that income has to come from an employer to an employee. So if the employer is employing other people and compensating those other people, then I would submit that very detailed and specific findings would be necessary in a case like that in order to, you'd have to
But
calculate.
do we have a problem that no one seems to think that anybody filed a motion for further findings of fact?
Again, I have not seen such a motion. I was not counsel to the appellant at the time, but I agree with the court that additional findings from the trial judge would have been helpful.
Thank you, counsel. As I indicated, I do think, I didn't follow it up with questioning any further because I didn't think anybody was really prepared to address it. So I wasn't trying to embarrass anybody. But we do think that there may be an issue as to the jurisdiction that we would be interested in having counsel address. And so I'm going to suggest that if either side wishes to submit a supplemental brief within 14 days, I think that brings us to January 20th, if I'm correct, as to the jurisdiction of the district court to act in this case on a foreign judgment without either the judgment having been domesticated, and noting also as well there's no writ of execution. And I would refer you to the Faith Temple case as to whether there's jurisdiction for the district court to enter a disclosure or to have a disclosure hearing at all. So I would say January 20th, simultaneous briefing. And with that, we will be in recess on this matter, and otherwise await the supplemental briefs and take the matter under advisement.
All rise.
Good afternoon. You can be seated. And the matter before the court is Andrew Scoggin, 25-127, State of Maine, versus Trevor Averill. We are being streamed live on the web, both by audio and by video. I see counsel are present, ready to proceed. And if preliminarily you would introduce yourselves by saying your names for the record, together with the party you represent.
Kurt Peterson for the appellant, Trevor Averill.
Katie Sibley for the appellee, State of Maine.
Thank you. And Attorney Peterson, if you're ready to proceed, we're happy to hear your argument here this afternoon.
Thank you, Your Honor. Good afternoon. Your Honors, the abuse of children, who are some of the most vulnerable members of our society, is a type of crime that grips the hearts and the minds of the general public and of juries. It is especially in these kind of cases that the fundamental bedrock of our criminal justice system needs to be adhered to by trial courts and sentencing courts.
Counsel, you left the green light to go on immediately, so I'm going to jump in. Can I go to the issue about the evidence of the healing fracture of the ribs, as well? A two-part question. First, do you agree there's at least some evidence from which one could find that the skull fracture was contemporaneous with the fatal injuries?
There was some record evidence from the state, their experts, that testified that it was an acute injury.
I understand there was other evidence as well, but there's at least some evidence from which one could find that.
Yes, Your Honor, but from both the state and the defense experts, there was evidence that it was not an acute skull fracture.
But that doesn't that first of all put the skull fracture into a different category though than the healing fractures of the ribs, which everybody agrees is an old injury?
I would submit that it doesn't, Your Honor. This is not an injury where it is undisputed that it was occurring in an acute manner on the alleged date of violation on July 22nd of 2020.
It may not have been undisputed, but that's not the test for whether the evidence comes in.
Perhaps the hearing should have been held in order to assess that, Your Honor.
But then that brings me to the other question. Didn't defense counsel below, and I understand you were not defense counsel, but didn't defense counsel below not only not object, but affirmatively say, I considered objecting, I am intentionally not objecting, and in fact discussed some of the evidence through the expert testimony?
Your Honor, it was definitely on defense counsel's radar.
Isn't that really a waiver as opposed to simply an obvious error review?
I don't believe it's a waiver, Your Honor. I think this is a case where the court can review it under obvious error, as I believe the state has addressed in its brief that this is an obvious error. I think the waiver piece came in on the 403 issue with regard to autopsy photos, so I believe the court can review this under obvious error because this wasn't an affirmative waiver it was just noting on the record that I might object or might not, and then eventually took what I would assume be the trial strategy.
Well, it wasn't just I might or I might not in the future. He's like, I'm not going to right now.
Right now. I think it was brought up later on, again, later on in the trial. I need to look back at my notes because this is an 8-day trial, and I have notes on this, but it was brought up again, but very late in the trial about objecting to that or objecting to, I think it might have been in the context of closing argument, they started talking about these old injuries that the infant had purportedly sustained, Your Honor. And Your Honor, so back to these bedrock foundations, one of them is to not have evidence be admitted that is going to be unfairly prejudicial to you. So first, looking at the autopsy photos, Your Honor, this is a 2-month-old child, and autopsy photographs are being admitted, and they carry a de minimis probative value, and especially compared to the very high danger of unfair prejudice that those photographs have.
They have a minimal probative value by themselves. And I think if the state wanted to put up photographs of a child in extremis or passed away, just left it at that would be a problem because it doesn't have any probative value at all. But as we've said in a line of cases that goes back decades, if the photographs are part and parcel of the expert's testimony and allow the expert to explain what's going on, it enhances the probative value. And isn't that what happened here, that these photographs are not inherently gruesome, but they have a great deal of probative value when mixed in with the expert's testimony?
I disagree respectfully, Your Honor, that the autopsy photos do not carry that level, because in this case, you have a wealth of experts that are testifying about the injuries sustained by the infant. You have a large amount of imaging that is submitted where the experts are looking and pointing to these injuries that are shown on imaging. You have a PowerPoint where one witness is talking about, this is something that breaks my heart because you can see that this brain is dead. So the state got the point across. These autopsy photos didn't need to be admitted. They were cumulative, and the trial court should have considered that.
Well, if they're cumulative, aren't they essentially then harmless?
No, Your Honor, and especially in conjunction with the other...
Especially under an obvious error review, since all but Exhibits 3 and 4, I believe, were not objected to.
Your Honor, but looking at those photos and also looking at the admission of the body-worn camera footage, when you take into account both of these items of evidence being admitted, where a jury is then seeing, in addition to autopsy photos for a 2-month-old, then seeing a 2-month-old lying on a couch, gray and ashy, and is not responding. Come again,
I think
Your
it was
Honor.
on the floor.
Or it was on the floor of the ottoman, Your Honor. I don't remember if it was the ottoman or the floor, but I take your point. In any event, unresponsive, CPR, life-saving measures are being performed on this 2-month-old.
So you're asking us to find an abuse of discretion because the probative value is substantially outweighed by the danger of prejudice?
Yes, Your Honor. This is classic 403 issue that we've raised in our brief.
And don't we defer? It's a very high standard, a very deferential standard we use in looking at the trial court's exclusion or admission of a document or an exhibit.
It is a deferential standard, Your
Well,
Honor.
and in the footage, also, we have him in the background making statements. So isn't that pretty relevant?
It is probative, Your Honor, but again, there were multiple witnesses who testified about this, and then they also mentioned how it's probative because, it shows the quote-unquote crime scene. And I take issue with that because there was also a walk-in
Fine,
scene.
put aside crime scene, but we've got Dad in the background making statements throughout the video that was admitted.
None of which were as highly probative as some of the other statements that were later made in the interview, Your Honor, is what I would argue to this court.
But isn't the defendant's demeanor in the immediate aftermath, or when the emergency responders are first on scene, the immediate aftermath of the injury, isn't that highly probative and something the jury could consider in determining whether the state had proved its case?
Yes, Your Honor, it's probative to show the accused demeanor.
And a picture is worth 1,000 words, right? So you have a video where the jury can actually see, as opposed to listening to somebody else describe their observations of your client.
Your Honor, from our view, this could have been, Trevor's demeanor at the scene. That can get in without showing. You said it yourself, Your Honor. Picture's worth 1,000 words. That evidence can get in without showing the HA, unresponsive, having CPR performed on her. So I agree that it's probative, but 403, just because that piece is probative doesn't mean that if there's if there's a high risk, that it would be prejudicial to Trevor such that it could cause the jury to make a decision, not based on the evidence or the medical evidence, but based on their emotions. That's what 403 is here, and that's why we believe that is reversible error under 403.
So
Is
the
that
unfairness...
Is that what you think is your strongest argument, or do you want to go to that in your last 5 minutes?
I think all the arguments are my strongest arguments, Your Honor.
No priority.
Well, Your Honor, I just would, just to end on the 403 piece, I would note that the trial court takes a lot, or really relies on this court's ruling in Crocker. I mean, it's as if it's like dispositive to the trial court's analysis, is that, Crocker held that this was okay, but it is not a dispositive case law, and it is distinguishable in this case.
Well, I was trial counsel in the final Crocker case 45 years ago, and the pictures there were far more extreme. I mean, you haven't seen them, but they're way, and if the court was blessing that at that time, it's, 10 compared to, a 1 here. So Crocker, I think, still is good law.
Yeah, I think it's still good law, Your Honor, but it's not dispositive of the court's analysis. And as you might recall, it also showed a malnourished body. Yeah. It showed it showed scarring. It showed cuts and it showed things that supported that this was ongoing child abuse towards the victim in that case.
Right.
We don't have that here. It's not the same type of case as Crocker. It's
On the other
distinguishable.
hand, the pictures are not, of the child in the video are not gruesome. It's sad, but it's not gruesome. It's sad because it's a 2-month-old child. I mean, the whole case is sad because it's a 2-month-old child. But there's nothing particularly otherwise inflammatory about the picture, the video of the child being resuscitated.
That was the trial court's finding. I'm not sure if that was the trial court's finding on the autopsy photos, Your Honor, that they were not
Well, and
gruesome.
then the autopsy photos, same thing, that there's basically 2 photos that show the infant, the autopsy at autopsy, and then the rest of the autopsy photos are really samples photos as opposed to showing the whole body or doesn't look like a child. They are slices and things like that.
In Your Honor, under 403, it doesn't have to be gruesome to be something that is an abuse of discretion to exclude.
No, but it needs to be
So-
unduly prejudicial.
Yes, Your Honor. That's correct. And Your Honor, turning to some of the other bedrocks I was talking about.
Tried to give you that opportunity.
Thank you, Your Honor, for the segue. Was the sentencing in this case is something I'd like to touch on. In this case, the court heard a case recently up in Penobscot County where it is addressing when a trial court or sentencing court finds that a defendant is not remorseful. In that case, defendant testifies, doesn't allocute. In this case, Trevor doesn't testify, Trevor doesn't allocute, and the
But
sentencing
Trevor
court...
does say things like in that footage and in his interview.
And the court, in the sentencing, specifically referenced his demeanor and actions and statements at that time, as opposed to something that happened at trial.
Back in 2020, Your Honor, is what the court's referencing is Trevor's interviews with law enforcement while all of this is happening. But ultimately, what we have here is a sentencing court that is dealing with somebody who is invoking their right to remain silent, not allocuting, which is their right, and the trial court saying that he's not remorseful and he's not taking accountability for his actions. That the sentencing court cannot just simply rely on that.
I understand the risk, counsel. I mean, and I think we tried to highlight that for everybody in the Ellis decision, that
Yes,
there's
Your
a
Honor.
risk. But in this case, the court specifically referred to, in that context, his statements and demeanor long before trial. And that is, the court specifically referenced that as being the basis upon which it was finding a lack of remorse or responsibility.
Your Honor, I think there is at least ambiguity to that extent. That
You're
the trial-
relying on the language, sorry to interrupt, the court said he, quote, has never taken responsibility. So is your argument that extends forward through the trial?
Yes, Your Honor, that it's not just about the interviews that were given 5 years ago, that it was about the fact that he pled not guilty, he had a case pending for years, took the case to trial in over 8 days, never once took responsibility
I
for
understand
this,
you're
and admitted
arguing
in
all that, but the
sentencing.
judge didn't say any of that.
No, but Your Honor, it didn't. But the judge did say that he has never taken accountability or doesn't show remorse for his actions. And this court has held that when there's even an ambiguity with regard to a sentencing court making a statement like that it should be read in favor of the defendant. I don't think that's verbatim, Your Honor, but I'll read it in my blue brief and come back and report back on it.
If the court didn't say never, if the court said he did not take responsibility at the scene, I consider that to be an aggravating factor. Would that put a different spin on this?
No, Your Honor, I don't believe it would. Our position is that this should have been treated as if anything, may I finish, Your Honor? Or Chief Justice, may I finish? It could be used as a mitigating factor if he were to have taken responsibility, but simply because he's never taken responsibility and didn't back in 2020, that brings into play the problem about sentencing somebody as an aggravating factor for not pleading guilty or taking responsibility.
Thank you.
Thank you, Your Honor.
Attorney Sibley?
Thank you, Chief Justice Stanfill, and may it please the court. Just after midnight on July 22nd, 2020, emergency personnel responded to a 911 call regarding an unconscious 2-month-old named Harper. Despite the valiant efforts of numerous emergency and medical staff, Harper died. Trevor Averill, Harper's father, repeatedly denied harming her, maintaining that she became unconscious only after choking while he fed and burped her. The medical evidence told an entirely different story. Harper had sustained catastrophic injuries. Those injuries included severe retinal hemorrhages in both of her eyes, extensive and acute bleeding in her spinal column, an acute fracture on the back of her skull, and injuries to her brain so severe that her brain was effectively dead. Every physician who attended to Harper agreed the only plausible medical explanation that could account for all of her injuries was inflicted trauma. And because the effects of her devastating injuries were instantaneous, the fatal injuries could only have been inflicted by the person in sole care and custody of her when she became symptomatic. And there is no dispute that that person was Mr. Averill. The trial court did not err in its evidentiary rulings. Indeed, Mr. Averill has waived any assertion of error regarding much of the evidence, as he either did not object, withdrew his objection at trial, or presented evidence on an issue himself. Even if this court disagrees, the autopsy photographs, body camera footage, and evidence of Harper's fractures was properly admitted. Mr. Averill's assertions of prejudice are no more than the prejudice inherent in every case involving the death of a child at the hands of a parent. Finally, the trial court committed no obvious error when imposing Mr. Averill's sentence. The court's finding of Mr. Averill's failure to take responsibility is supported by affirmative evidence in the record. That includes his repeated, implausible explanations for his daughter's condition and injuries at the most crucial time, when medical personnel was trying to save her life. By doing so, he placed his desire to avoid accountability over the medical needs of his infant daughter. It is difficult to imagine a scenario more glaring in its affirmative demonstration of a lack of remorse than a father purposely giving implausible information about his child's health as she dies in front of him. For these reasons, and the ones articulated in the state's brief, this court should affirm Mr. Averill's judgment of conviction and sentence, and I'm happy to take questions at this time.
Can we go through the evidentiary errors that you think are waived, which are obvious error, and then you also mentioned that when he presented evidence on an issue himself, that should affect what standard of review we give it, I think. Is that what you were saying as to when he presented evidence? Especially that last point. To which are you referring?
I can break it down, Your Honor. So the state's position regarding the autopsy photographs, that argument is waived. Regarding state's exhibits 6 through 20.
All photographs, including 3 and 4? I mean, he objected to 3 and 4.
If my recollection of the motion in limine transcript in the trial transcript is correct, objected at the motion in limine, the court overruled that objection, but when it came time to trial, I believe the objection to 3 and 4 was withdrawn. I may be misremembering that, Your Honor. It should be cited. I don't have my brief in front of me. In any event, 6 through 20 definitely waived. There was no objection at the motion in limine or at trial to those photographs. Regarding the rib fracture, again, the state's position is that that argument is waived. I believe there's a discussion on the first day of the trial. It's around pages 14 to 15, where counsel is actually discussing that. They weren't objecting to this evidence.
Can I clarify, though, a waiver versus simply unpreserved? I mean, you said that the autopsy, the photos 6 through 20, and I think it was 63 or something like that, that they weren't objected to. Were they affirmatively waived or just not objected to?
So at the very least...
Or are you using those interchangeably? That's what I'm trying to clarify.
I'm trying not to use them interchangeably, Your Honor, and I certainly apologize if I am. 6 through 20 are waived. There was absolutely no objection whatsoever. Now we're here on appeal, and for the first time...
Okay, but that's my point. Is no objection, is that the equivalent of a waiver?
Regarding 6 through 20, I would say yes, because I believe some of those photos, not all of them, were actually used by Mr. Averill's own experts in their testimony.
Okay.
At the absolute very least, Your Honor, regarding the autopsy photos, these arguments are not preserved based on either the lack of objection or...
Well, there you go. Use that language, and then we won't have any.
I will to defer to the court. It's either waived or it's unpreserved at the very least. Moving on to the rib fracture, again, I believe it's on the very first day of trial where there is an affirmative, we are not objecting to this evidence. Regarding the skull fracture, that is most certainly waived, as that is at least one of the pieces where Mr. Averill himself introduced expert testimony in evidence on that issue. By doing that, he has waived an argument that admission of that evidence is in error. So really, from the state's perspective, the only issue that is either not waived or unpreserved by Mr. Averill is that portion of the body camera footage that was admitted at trial.
What about the prosecutorial statement that was objected to?
The expert.
Yes, I viewed that as a...
It's not evidence, it's argument.
A separate issue, Your Honor. But
I was just going to say, as a predicate to that, all of us have trial experience. We know what it's like to be in the pit, in the arena, in an emotionally charged case, speaking extemporaneously, and you don't get a chance to parcel the words. They come out, and then we sit here afterwards reading them very carefully, word by word, and I think the troublesome sentence is, the defendant has given a very implausible story about what happened to the victim, and they hired experts to support their implausible story. I just added emphasis to that, which I'm sure was not in the original, well, probably wasn't in the original. But just standing alone, taking the four corners of that, it says that the defense hired somebody to support an implausible story. It seems problematic.
When it's viewed within the entire context of the argument, what the state is saying there is that the doctors who were actually, I don't want to say on scene, the doctors at the hospital treating this, the argument is they had a better understanding of what was going on because they were there, they were treating her, and that based on that testimony, Mr. Averill's explanation, as well as the explanations of his experts to explain all of these various injuries, was implausible and unsupported. In the Harding case, this court did say that bringing up payment, hired,
That's all okay. Do you see any problem with that sentence, though, that line there?
It seems to imply that they
hired experts to support that implausible story.
Leading with how the court asked the question, we all wish in the heat of the moment. I personally have never read a transcript of a case that I have tried where I have not parsed my own words and thought of 100 other ways that I could have said something better. It's why it's viewed within the overall context. And any potential prejudice that comes from that, it's really ultimately harmless because there isn't a high probability that this affected the jury's...
And that was going to be my question. Do you concede that this could be perceived as error?
I can see that it could be perceived as such. My position is it is not, but ultimately it doesn't matter.
It's not because you view it not in isolation, but in the context.
Yes, and not only within the context of what the state argued in its closing, but the instructions that the court gave. The jury was specifically instructed that closing arguments are not evidence. The court gave a curative instruction after Mr. Averill's objection saying, you, the jury, are the sole determiners of credibility for the witnesses.
And that it doesn't matter who called the witness.
Exactly, as well as expert testimony is to be evaluated as all other evidence. And Mr. Averill has raised no issue regarding the court's instructions, and from my reading of the record, there is nothing to overcome the presumption that the jury in fact followed those instructions. And they did acquit him of murder. The reasonable inference from that is they weren't inflamed to passion or decide on an emotional basis by the autopsy photographs, by the body camera footage, or even by the prosecutor's closing argument.
So you and the chief have underscored the reasons why it has to be read in context, and that under any analysis it would be harmless error.
From the state's perspective, yes. Again, first position is this is not error. Any perceived error is harmless.
Okay.
Could you address the sentencing argument? Because on the one hand, the trial court said he has never taken responsibility for his actions. But then the court, and I might have the order wrong, but then the court sort of speaks specifically about Mr. Averill's statements to the first responders and about what had happened. So that suggests, that the court's finding is sort of based on, I think, what the court perceived to be falsehoods to the first responders, which is, I think, a legitimate basis to find aggravating. But then it's, what do we do with this? He's never taken responsibility. That suggests some penalty maybe for not having, or for insisting on a right to trial, which we've said is improper.
From my perspective, Your Honor, when you look at all of the court's comments in context, the court either implicitly or, and definitely not explicitly, made any reference to Mr. Averill's right to stand trial. While, yes, we could parse out what the court meant by never, I think with what the court followed with, which was that very specific affirmative evidence in the record, what he was doing and saying at the time that was going down, shows that that's what the court's focus was, not that Mr. Averill decided to have a trial.
But that's less clear by the use of the word never, notwithstanding the focus upon what he was doing at the time that the medtechs were there working with the trial.
Or you're suggesting that the trial judge gets the same grace that the counsel should get about being in the heat of the moment?
That's a good answer. Go with it.
Yes, all of your honors have had trial experience too. I am not going to assume, but I would surmise have run into a similar situation looking back, either as a trial attorney or as a judge, and saying, I could have said that just a little bit better. I even do it with my briefs to your honor. After it's submitted, it comes back from printing. I still parse it out and find all of the things that I could have said far more clearly.
And this is an obvious error review, right? So we're looking for a miscarriage of justice?
Exactly. There was no objections or issues raised to the trial court. This is obvious error. Under that standard, it's simply not.
Just as a little bit of a sort of side note, though, isn't it a problem to say that there's somehow a burden to object to in a serious case like this, to what the judge said in sentencing after the judge says it, when counsel have finished their arguments and everything else?
I can understand how that potentially poses a difficult situation, but in many, many contexts, not just in sentencing, this court has said it's not a fact-finding body. It's a body of review. So these issues need to be raised to the trial court for the trial court to correct. In the State versus Servill case from several months back, the court had already ended its presentation and imposed its sentence when Mr. Servill, in fact, was able and did raise objections to the trial court, which made it very difficult for the state on appeal to argue that the issue hadn't been raised or that it was an obvious error standard. So while I could certainly understand the awkwardness counsel would feel about doing so, it should be raised to the trial court, to the sentencing court, for that court to have an opportunity to fix any potential error.
There don't appear to be additional questions.
Thank you, Your Honor.
41 seconds to spare. Attorney Peters.
Thank you, Your Honor. Your Honor, starting with the prosecutorial error, State v. Harding does not support the proposition that what the prosecutor said in this case is acceptable. That's not what State v. Harding says. State v. Harding, what's quoted by the state goes on in the quotation and explains that error.
But can I ask you this? I mean, what you're arguing is there ought to have, it's reversible error at this point. I mean, at the time, it was a motion for mistrial, and the court denied the motion for mistrial, but did in fact give a curative instruction, which everybody seemed to pretty much agree they didn't agree that that was enough, but that if you were going to give an instruction, that was an appropriate instruction, right?
Right, Your Honor. Where in Harding, the issue was waived by the curative instruction. So in Harding, the issue of prosecutorial error is waived, and this court doesn't address it from a preserved standpoint, like in this case. I agree with Your Honor that the counsel says that this is a sufficient curative instruction, but then it goes on, defense counsel goes on to say,
But we're left,
but I'm not.
is it enough to have, for the judge to have declared a mistrial at the time, or for us to flip on that basis?
In this case, Your Honor, where it boils down to the jury's credibility determination of countless medical experts, yes, Your Honor, because that's the fundamental job is to determine the credibility of the medical experts. And that's the biggest decision the jury had to make when they went back in there, is which medical experts to believe. And the prosecutor, by saying that what Trevor said was implausible, in other words, wasn't true. And then they hired defense experts to support that implausible, untrue story. It's opining on the credibility of a witness in a case where credibility is paramount. So yes, Your Honor, that is enough for this court to overturn, to vacate the conviction and to send it back for a new trial. Thank you, Your Honor.
16 seconds to spare, in case you were wondering. I know you see that yellow light go on. Counsel, thank you very much. In this case, we will, as is our ordinary practice, take the matter under advisement and issue a written decision in due course, but thank you. With that, we're in recess for the day.
First, I made it further to you before the Honorable Justices of the Supreme Judicial Court, City and Law Court, may enhance the part and give their attendance here at 10:40 tomorrow morning, as this court announced you in the United States of Maine, in this honorable court.